until it is amended. This is like the rock of Gibraltar. There's a panacea. Let them go and amend the law. For now, the Supreme Court, you see, those authorities that the judge was given, authorities of Australia, they do not have the equivalent provisions of section 235 and order 8 to 16. They don't have it. Okay. Yes, my reaction is that the case has been won and lost. By the grace of God, we won the case today in favor of Senator Kabiru Marafa against the APC, and therefore in favor of Governor Dr. Bello Mohammed Matawale, the governor of Zamfara State. The Supreme Court was clear that it had the powers to make a consequential order so as to give vent to a judgment it has delivered. It has done so before in the case of APC versus Karfi. The Supreme Court today also reiterated the judgment by Justice Kayode Esho in the case of Arcon number 4 versus Fasasi, that being the last court of the land, its judgment is final for all times, final in the sense of finality, and that no power can alter the judgment. I described Supreme Court judgment as the rock of Gibraltar and the Mount Zion that cannot be moved. In my closing remarks after the judgment, I told the Supreme Court that there is a solution, there is a panacea. The panacea lies with the National Assembly to amend Section 235 of the Constitution, to amend Section 285, subsection 12 of the 4th alteration, to amend Order 8, Rule 16 of the Supreme Court rules, all of which said Supreme Court is final, it cannot review its judgment. The Supreme Court cannot of its own sit on appeal over its judgment. It cannot of its own decide to amend the law. It has no power to amend the law. Law can only be amended by the legislature under Section 4. And in any event, the dissenting opinion given by the Honorable Justice Mweze were cases cited from other jurisdictions which did not have the equivalent provisions to Order 8 through 16 and to Section 235 and Section 285, subsection 12. So they were talking about their own jurisdictions generally. If you remove these laws, then the Supreme Court surely can amend its own judgment. By the way, if we were to go by the argument of the APC that the consequential order was not in their favor, they agreed that the Supreme Court could therefore make consequential order, but that it was not in their favor. And that the consequential order they wanted made was to order APC to bring candidates to contest, to be allowed to conduct another primary. The primary ended on the 18th of October, 2018, 1.5 years ago. And by Section 285, subsection 12 of the 4th alteration, election petition matters, pre-election petition matters end 60 days later. So where are the primaries upon which elections will be conducted? So this is a good judgment. It means the justice of the case, and we have to abide by it. Those who are not satisfied for now, let us go to the National Assembly to amend the law and give the Supreme Court power to amend and review and reverse its own judgments. Otherwise, we are going to have what you call a floodgate of cases, as the Supreme Court noted today. I can assure you we have cases like the 1931 decision in Eshugbayi Eleko versus Minister administering Nigeria. We are going to have cases like Ekpendu versus Erika on land law. We are going to have cases to review the issue of Idi Igi and Ori-Ojori inheritance system of the Yoruba people. We are going to have judgment delivered even when we had West African Court of Appeal to be reviewed. So this Supreme Court must remain steadfast. The only thing I urge the court to do is to scrutinize rigorously, vigorously all cases to ensure that justice is done in every case, because law is but a handmaid with which justice is delivered. But for now, we are stuck with the law as it is. I am a revolutionary, but I do not believe in a revolutionary sense that take the laws into the shredder. Otherwise, there will be a state of chaos and anarchy. Even amongst mad people, there is orderliness. So we must have orderliness. Thank you. Court awarded against the appellants, that's APC and the Yari group, and in favor of the 1/1 to 1/40th respondents, the cost of 2 million naira. I do not know whether it is for each, which will be 280 million naira, or whether it is single, which will only be 2 million naira. When we get the final judgment, we will read it and interpret it. Thank you.
Majority of the judges have given their decision. But as I said before the court, that as much as I am bound to accept majority judgment, I prefer the dissenting judgment. And I will recommend anybody in the whole world to go and read that judgment. The Supreme Court of Nigeria cannot be in isolation when the whole world is tilting towards a different form of rigidity that the present Supreme Court is placing on all of us. I am happy to hear the lead judgment saying that this Supreme Court of Nigeria is the most hard-working Supreme Court. I have always said it's a self-inflicted injury. They brought the problem onto themselves, and they have themselves only to blame. And it is something they can cure, because they took upon the responsibility which the Constitution never gave them before. I thank you all, the press. As I told the court, a dissenting judgment today can be the judgment of the Supreme Court tomorrow. I'm therefore appealing to everybody to read that judgment, the dissenting judgment, and form your own opinion. Thank you very much.